Welcome, 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 welcome. We're here. Hey, we got Mel here today.
Mel's here.
Hello.
Dr. Jon, Melvin Welch.
JD.
JD.
Yeah.
Melvin Welch.
Yeah.
JD.
Doctorate of Jurisprudence.
And then it's just me who is hey you. Okay. So I'll just be over here and we're leaning in. So we're sharing a mic today.
Yeah.
That's going to be good. So if I give Mr. JD here a peck on the cheek, you guys won't mind, would you?
I won't mind.
You won't mind?
No.
Anyway, welcome. This is a great show. Thank you for being here. And if you're new here, as always, there's a little red button on the top that says frozen screen. Just reconnect. It's the reconnect button. It doesn't disengage you at all. Just go ahead and push that and it'll refresh your screen. It's a fun and safe place here. There are going to be poll questions. Get in the chat, talk to us. That's why we're here. We want to hear your questions. Today is Hemp Legal 101. And that's why we have our resident general counsel, and he's kind of a scary dude.
Yeah, no.
You're a scary dude.
No.
Yes.
Noble.
He's scary.
Noble savage. Is what I am.
Noble savage.
Yeah.
Oh, I like that. That's good stuff. Okay, sorry. Okay, so also this no holds barred questions, anything, any questions work, simple or tough. Join the chat on the questions, invite your friends. There will be a replay. There will be a replay. There will be a replay. That's the most often question we get. So
yeah, it is.
There will be explore our resources, live tours, CBD Jam sessions, and you guys are just popping on the CBD Jam Sessions. We're answering a lot of questions. You guys are awesome. I just want you to know that. We're learning a lot from you as we go. So thank you.
On that note,
yes.
We have basically 5 pages of unanswered questions still. I mean, and we've been kind of going through them.
Wow,
you guys have really hit
that
up.
head.
We really appreciate the questions that we get from you guys. So keep on bringing them in. We're working on producing, like videos around those, and then also any kind of written answers and FAQs and things like that. And then of course we're going to be talking about our answers as we go along. Yeah. So, but they're really helpful. Any some of the ways you guys, when you ask a question, it just is. Sometimes you'll like 5 different people ask the same question in different ways, and it's really helpful to see how people ask them. So
and it also allows us to drill down with the right answers.
Right, exactly. Right? Yeah.
And then we can look at it from various vantage points. So good stuff. So yes, those are very welcome. And we will be adding those to the FAQs on our website, but we're also talking about having a video FAQ kind of thing.
Yeah,
so
there's a whole bunch of those coming out.
Audio and future podcasts. And
how many did we do last week, James? We did 8. Yeah, so we did 8 videos last week on, just very discrete subjects. Unfortunately for you guys, I did them, but but they're good. They may be a little dry, okay, but they're really great information.
That surprises me from an analytic chemist, PhD.
Well,
how would they be dry?
I don't know. I can't imagine.
You're not a droll individual,
but the topics, whatever.
Okay.
Oh boy, I guess.
Yeah. Just so you know, these guys have known each other for a long time. How long have you guys known each other?
Over 20 years for sure.
Over 26.
Yeah, 26. Oh my gosh. Wow. Yeah.
Time flies when you're having fun and when you get old and you don't remember.
Yeah.
Okay, calculator library is coming. We keep promising it's there, it's close. We're finding the graphics that Dr. Jon is liking, so we're getting much closer.
I have standards, okay, that's it.
And I have no standards, so mini course library is coming, etc. So we do have, sorry, wrong page. This week's winner, Sean Mueller. Thank you. And that was from our email sign up.
Cool.
Yeah.
Sweet.
So congratulations, Sean Mueller. Nice. Good job. And keep those cards and letters coming. Letters are welcome.
I think Sean Mueller is a UMD guy.
It certainly is a familiar last name.
Yeah. I think I know Sean Mueller. So that's pretty cool.
Oh, wow.
Yeah. Yeah. So I think he had, he went to UMD in the chemistry department. So that's pretty cool.
Okay, but you guys don't talk about UMD. You refer to yourselves as?
Bulldogs.
Bulldogs, yeah.
Go Dogs.
Bulldogs. Go Dogs, Bulldogs. Okay, so good. Congratulations, Sean. Good job. Come on. Next week, apparently, we're talking about everything facilities.
Yeah.
Wow.
Yeah, it's a dry topic, but we will not make it dry.
We never do.
No, it'll be a great time.
We're
going to talk about, everything related to, the different requirements, the different occupancies, permitting, all the stuff that.
Oh, see, that's good stuff.
Yeah, it's all the stuff that kind of like, okay, we want to get into the business. Oh, we have to go through all that. Oh my word. So we're going to try to illuminate you on some of those requirements.
And one of the ways that Dr. Jon has mentioned that to me in the past is it's just about everything that your architects and engineers don't know.
They want to bother us for. So, let me give me your watch. Let me tell you what time it is. That is exactly what happens. They'll be on the phone, and then they'll get the owners to call us up and try to get us the information. So it's kind of funny. Anyway, it happens. Whatever.
It does happen.
Okay, whatever.
And you're very familiar with that, huh, Mel?
Yeah, I'm available for answering questions. You may not get the answer you like, or even any answer that's close to what you've asked, but I'll talk. That's what I'm paid to do.
I love it. Now, and that's good. So today we're jumping in Hemp Legal. We're already getting questions in, so keep them coming. Right now, first question, right out of the gate. Do you want to do a little intro, Mel, for who you are? Or do you just want to jump in?
I don't know, John. What should I do?
Yeah, why don't
boss, we? And so I do.
Yeah, why don't we just do an overview of the legal situation with hemp, starting at the Farm Bill, the nuke bomb that went off when the Farm Bill passed, signed into law, and then what has happened and transpired legally since then.
Yeah. All right. Oh boy. Well, I'll try to simplify it. So. Industrial hemp was previously a Scheduled I controlled substance, basically defined under THC, marijuana, tetrahydrocannabinoid, and I think it was separately scheduled.
Wasn't that under the Controlled Substances Act, right?
Yeah,
that's
correct.
Where that originally was. Yeah.
Yep. And so then in 2014, the United States government passed the 2014 Farm Bill, as it's called. I can't remember the specific statutory reference at this time, but that opened the doors to states to establish industrial hemp pilot permit programs, whereby if they were growing hemp, processing hemp for educational and research purposes under state regulatory programs that had been validated by the DEA, essentially that an individual who applies for it and receive that permit could grow hemp, could process hemp, had to work in partnership with a university, or at least in most states, a university or other type of a research facility for whatever the particular purpose may be. Purposes were not specific, they were not limited, it could be very broad. I know that here we've done a lot of research on terpenes. I don't know what else we've been researching on. You have quite a broad listing of different things we were looking at.
Everything.
Yeah, everything related.
Oh, and just I'm going to interrupt you for a second. Talk to the smiley face in front of the camera.
If I look at the camera, I see myself, and this video.
It totally drives me crazy.
20 to 40 pounds easy. This is ridiculous.
Now, is that the disclaimer?
Yeah, I'm looking at
this.
It's
the legal disclaimer.
I'm sucking it in right now, and I look like I'm round. I'm not pleased at all.
You look good.
Oh, thank you.
Noble savage.
I've got COVID hair going on here.
Don't we all?
Yeah. So after 2014 Farm Bill, the 2018 Farm Bill was passed and signed into law, and that descheduled industrial hemp from that list of controlled substances. So essentially, it opened the door up to complete legality throughout the United States. Now, there are some caveats that there are different states that had specific restrictions on industrial hemp through their own statutory guidelines. Idaho is the most immediate one that comes to mind. As of right now, I think
South Dakota too, right?
South Dakota is another. Right now, I think we're at 46 or 47 of the 50 states have removed hemp from their scheduled substances, do have hemp programs, and under the 2018 Farm Bill, there is, at least federally, anyone can get involved in being processed or permitted to process, to grow industrial hemp, so long as they apply for it, receive validation. The program under the federal guidelines is not finalized. The regulations have recently come out that are interim final rules. They're still finalizing. I'm using final a lot there redundantly, but they're still finalizing the rules for basically the whole process, how you apply for, what seeds, what strains can be grown. The definitions are fairly established, such as what is industrial hemp, what is the definition of that. But testing procedures, regulatory requirements for those testing facilities, individuals that can be permitted process, et cetera. Those rules have generally been established, and even where they're not established by the federal government, you're able to go through your specific state program that have had their programs up and running for a number of years, and at least for those that have them. So.
Super. Hey, so okay, let's start off with the farmer. Okay, farmer wants to get in and start making hemp biomass. Okay, and they obtain a license from the state, and they're ready to go. They got their field registered with the state. What are the potential legal issues that the farmer might encounter with the grow operation and then moving their product out into processing or out into the market?
Right.
What does that process look like?
Well, first step, obviously applying for, filling out the application, getting your proper application from whatever state you're operating in. Most states have their industrial hemp programs listed, usually in the Department of Agriculture website. You can find the proper documentation there to fill out. So there are differences from state to state. I know that certain states have specified strains that are allowed to be grown. Other states do not go that far. Everybody is subject to the definition of hemp, which I wrote down here quickly. Let's use it for reference. Hemp means the plant species cannabis sativa L in any parts of that plant, et cetera, et cetera, et cetera, with a delta-9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis. So essentially hemp is cannabis sativa L. Marijuana is also cannabis sativa L. The big difference here is that we're dealing with a THC, delta-9 THC level of less than 0.3%.
Let's talk about that.
Yeah.
Okay, so
that we're skipping over a lot of stuff for the farmers still.
Okay, but let's talk about specifically about the delta-9 versus the acid form of, there's you can have a strain with a high, not a lot of delta-9 in it, but a tremendous amount of acid form of THC. Would that be considered a legal strain?
All right, so this is what I understand in looking at the regulations and having conferred with a number of different permitted testing facilities. It's kind of an equation that determines what the delta-9 content is on that dry weight basis. You send it into your facility, there's established methods, established equipment that's used to test that level, and it's something like, I think you take the THC-A level times 0.877, and you add that to the
actual, they have an equation that will take it. Okay.
Correct. And
all right.
So if you got a delta-9 THC-A of, say, I don't
know. So what they're doing is they're converting essentially all of the acid back into the delta-9, and they're getting it. So you couldn't just use, for example, a cannabis strain that had a high THC level that had very low delta-9 and a lot of THC-A, because as soon as you send it to the laboratory, they're going to be converting everything over to delta-9 before they test it, and your crop is going to fail, right?
Correct.
I think that is kind of what we, the advice that we would give is just make sure that you vet your strains really well on that, right?
Good. Since you mentioned the word advice.
No, really I said quickly, vet.
You did say advice. Although I am a lawyer, I am not providing any legal advice to anybody here. None of that I say should be relied upon to any degree of certainty. No one here is my client except for United Science.
Okay, all right.
All right, with that disclaimer out of the way and CYA caveat, the regulations, at least, that were promulgated by the USDA here, their testing measure is 0.3 after decarboxylation, so
Yes.
after that acid has been converted,
Okay.
and on a dry weight basis. Now, this is testing is not a it is fairly precise, but there is regulation in how it's being done. So a lot of states have different timing for harvest after the testing. The federal regs that are coming out are saying, all right, you're getting your testing done. It's supposed to be done within about 15 days, within 15 days of the harvest, because that's going to be the best measure of when you're going to be within that compliant
So
level.
why don't you stop there and kind of go back and just explain, basically, when you plant some hemp, okay, they're going to get bigger and bigger and bigger, and then they're going to start to flower. And it's very important that you make sure that you understand when the flower develops, that it's going to continue to develop THC in there, and the THC level is going to climb and climb and climb and climb. Yep. If you just let it go and you don't do any testing, your crop may go hot. What happens when your crop goes hot?
Yeah, and so I always...
In other words, it's over the 0.3% limit.
Yeah, I always come back to this hot term, because I'm not comfortable with it. I think it's a bit of a misnomer. I mean, because you have these regulations in place, you're likely to be within, if you have good compliant material, you're likely to be within the range that you're supposed to be. I have to gather my thoughts, because I just got sidelined seeing you listening to the rambunctious folk outside. So within that 15-day period of time, that's where they're measuring that THC content to ensure it's compliant. If you go over, and there is some room here in a range, as it's laid out in the federal guidelines, you have about a 5% range for this THC. So if you test and it's likely to be within this range, 5% above or over, you're okay. And that's because there's issues related to
testing variance, right?
Testing variance, correct. I think 5% is a standard error, a standard measure of error. So as long as you're within that range, you're fine. If you go over, the feds do refer you back to the state regulations, and the state regulations are different. But generally, usually there's at least two provisions. One, an opportunity for retesting within a certain period of time, and number two, ultimately destruction of the crop. So if you have material that's going to be non-compliant, you have to destroy it, and you have to document that destruction to ensure.
So let's talk about what a farmer needs to do. Okay, I think that at the end of the day, you just got to test early and you test often. If you start to develop flowers and you have 3 or 4 data points for, do your own testing, find out what the THC level is, make sure that you're dealing with a tester that has a low detection limit, for example, so you can actually see that. Then you're able to really understand, okay, here I can see my THC going, and I can call my regulators in and have it tested at the right time and then harvest at the right time, rather than being blindsided by it after testing, and then they're looking into like a remediation effort, like, okay, well, you can retest or you can destroy your crop. Yeah, so you're gonna put a lot of money into your crops, so you better test. That
is a sound advice. And there's still a lot of discussion going on in how this testing should be done. How the testing is being done now is that the testers are going around, they're taking a bud, right? They're taking the purest form of the CBD in there. Now, that's not the only product that's coming off of it and being extracted, right? You've got fan leaf, you've got the other sticks and stems, depending on what process is being used. A better method, and you can talk to your representatives or talk to the USDA with comments, may very well be that you're sacrificing a whole plant. That whole plant is being ground up, and that is the testing itself. Because if I test a bud, I'm going to have a high level of whatever it is, CBD, CBG, whatever it is that you're measuring. I'm going to have a high level of THC, but that's not the final product. The final product, when I get in product into my facility here and we grind up the bud, we grind up the fan leaf, typically you're seeing a lower level of CBD, you're seeing a lower level of THC, and that's a more accurate reading of that content. That's what's actually going into the product, but that's not what's being tested.
Right. So, okay, so the farmer gets the crop, he's done the testing, he starts to put it all together, takes the water out of it, chops it up or whatever he's going to do. And then he gets a fit for commerce certificate. Is that not correct?
In some states, Wisconsin does.
Oh, Wisconsin does. Okay, so other states would just, there'd be no certificate at all?
I'm thinking of Colorado. I'm thinking of Oregon here. They've been established for a few more years. Oregon. Are we going to go down that debate? The Oregon Trail?
No, it's the Oregon Trail.
The Oregon. Okay, so in Oregon and Colorado, they don't necessarily require that the regulators come out there and conduct the tests. They'll do a random testing selection for who they're getting to, and that's, I mean, there's a lot of testing that's got to be done, and frankly, a lot of them don't have the financial leeway in their different departments to do that kind of testing. So you're not always going to see a fit for commerce certificate coming out of a particular state, but you should see a letter or some other form of official identification that they have provided testing, that the testing has gone to an accredited laboratory, and that those readings have been received by the state, and that it is okay.
Right. So us as a processor, we purchase a product, or someone's going to, toll with us, for example. Okay, so what are the paperwork then, that the legal paperwork that they need in order to transport it across state lines? What is that? Can you talk to that?
Sure. At a bare minimum, you've got to have the grower's permit that they have from their particular state or federal. This should be the first year coming out with federal permits for a hemp program, but there's got to be that permit that they have permission from the state to grow that product. Secondly, you're looking for that fit for commerce is the best example that you can get from a state for that product itself, having had the authority to be harvested. So Wisconsin has that. It's very easy. They bring in the permit, they bring in the certificate, you're usually good to go. Any other certificates, organic, if you're dealing with organic, you got to have those permit certificates as well. Otherwise, if you don't have a fit for commerce certificate, then you're looking for that official validation by the state in whatever form it comes, that this material is compliant and capable of being sold or harvested. We always send our own permit along as well. So if there's somebody's bringing biomass, we're going to send them our permit, so that they basically have where it's coming from and all the authority to have that material in their possession, and where it's going to and all the authority that they have to receive it. And that usually, we've never had a problem receiving any biomass that way.
Yeah. I mean, if you have the paperwork along with, on the contract, So if you have the paperwork on the shipment itself, stuck to it in an envelope there. If there's any questions, then you have the testing, you have your license, you have the shipper's license and the receiver's license all in the packet. So if there's any inspections, that, hey, there's the paperwork packet for you.
Yeah, the more you can document this, the more you can paper up your shipment, the better off you're going to be any time that you might run into a dispute or any other issue. Hey, I have authority to have this. I have the authority to harvest it. Here's the proof that it is what it is, whether it's a COA, whether it's the official letter, and here's where it's going. You don't want to get involved in any dispute with the government. Even if you prevail on that, you're going to be tens of thousands of dollars in months down the line.
Your quality assurance is going to need that paperwork anyway. So when you receive it into your processing facility, they're going to review all the paperwork, make sure that the specifications on the purchase order match the specifications of what we purchased or whatever, and then put it into quarantine, get testing, and then release it after that. So, I mean, they need that paperwork anyway, right?
Yeah, that's correct. So, bing, bang, boom.
Bing, bang, boom. All right. So what are the options for a hot crop? Let's just kind of go back to the farmer. Look, if you have a hot crop, you're pretty much, it's pretty much done.
There's not a lot of leeway.
There's no way you can, there's not a lot of leeway.
There's one ultimate resolution to that crop, and that is that it's going in the furnace, at least if you're in a state that doesn't have marijuana as legal crop. If you're in Colorado or another state that has that, you may not be in the same situation, but you're not going to be able to sell that crop as a hemp crop, and you're certainly not going to be able to transport it across state lines.
Okay, second thing I want to just mention on testing. There's a lot of testers that are out there that are like in-field testers. I would just recommend in that case that you have the proper calibration and limit of detection established for that piece of equipment. I'll tell you why that matters, because if it goes to the state lab is going to have their limited detection, okay, and you might not have, maybe you'll be able to measure at this level, but the state is measuring at this level, okay? And so you would think that, hey, look, I'm measuring it with my tool and it says it's all okay, right? Because my limit detection is too high. So there are some, like in-field testing tools. I would be very cautious on that and until you validate your method. Just saying. You could go awry and you could have your whole crop having to be torched just on the basis of a poor measurement. So be careful about that.
As you read these regulations, there's not a whole lot of leeway. It's pretty strict in its final solution. If it's over the range that's allowable, it's done.
So let's go back then to the producer, okay? So, or the processor.
Wait. Before we do that, I want to make sure, because we also have testers in this whole process.
Yeah.
Okay. So the testers, if they're testing hot for remediation or analytics or what have you, I've got a question here from Matt in the Chicago area. So Illinois is new to this as of the beginning of the year. So he's asking, what can he do with his waste material that is THC or whatever in the state of Illinois, or how does he find out what to do with that?
You mean from a testing facility?
Yeah, from a testing facility.
I think you just would manifest that as waste. So it would be waste management, so if you have THC and it's in your eluent or in your solvents or whatever, you would manifest that as a hazardous waste.
Okay.
Yeah.
Matt, if that helps you and that answers your question, let us know if there's a follow-up question on that, but I think that's it.
Well, if it's a testing facility and that they're certified under the state as a testing facility, first off, as I understand it, generally speaking, at least it's from the federal requirements, base level requirements, you got to have an ISO 17025 certification on testing for some type of testing within that lab. Doesn't necessarily mean that the entire lab is certified, but it may be one of several testing methods is certified. If they're going to be working with a hemp program, the USDA is requiring a DEA certification as well. So if a company's going through that, they're going to have a fairly stringent review and audit that's going to occur in order to get that accreditation. I'm sure there's going to be one of the questions is how are you dealing with waste?
Yeah, that's SOP driven, right? Yeah. So, yep. And there's also like chain of custody items in there, also on that DEA license. So just want to make sure that the companies that are actually DEA certified, that they have the process and procedures there. So, which I'm sure if they have their ISO and DEA, they're pretty good on process procedure.
Jon mentions and also or approval by the DPH. I don't know what the DPH is.
Department of Public Health.
Okay.
I assume that's the Department of Public Health in Illinois.
Okay.
And they might have a state-specific rules related to testing. And I think that, like, for example, the marijuana testing, oftentimes the state will choose and approve certain vendors for that particular situation. So you want to make sure that you have a good relationship with the companies that are in your particular state, whether it's marijuana or hemp. And if you're going to run a hemp lab, you might as well do marijuana as well, if it's legal in your state. And set your relationships up, because those producers are going to be submitting, at the very beginning of the program, like in Illinois, for example, they're going to be submitting their here's the test lab that they have, and here's the certifications, and it'll kind of help with the approval process. So
okay, so to DPH is good, DEA, check out with that, and also then make sure you've got your proper ISO certifications. Check with your regulations as you're working with getting your testing lab set up, that you have all of those requirements and you're following them.
Right.
Okay. So good. One other follow-up to what we were talking about earlier in transportation and going through, and that is the COA itself.
we talked about, permits, we talked about other things, and in the testing, the way that testing is manifest is in a COA, correct?
Correct.
Okay. When we're looking at these hot levels or high levels of THC or whatever, is there a proper way to read? Are there any hidden landmines on the COA that our listeners should be aware of?
Well, it's hard. The first time you deal with the COA, it's like
What the hell
choose
is
your
this?
own adventure, trying to figure out what it all means.
Yeah, it's it can be. So you look at the C of A. If you have a good interpretation of that C of A, just by a chemist who knows what it means. I think that not all laboratories are equal. That's been one of the issues that we've had. Obviously, right, where you have a test in A does not match a test in B. I don't think we've ever had any issues though with THC level reporting. No. So that seems to be something everybody can dial in and nail. Yeah. Yeah, I think other things, may be an issue, but not those things. So, so it seems to be pretty good.
Okay. Looks like we're into, and in the transportation, we had the list of all of the things that you need to transport this product.
Right.
And does that include a compliant label?
No.
Not in this. Not in this. That only happens after it's been processed, and then it's processed into a product, and then that's where the compliancy with the label comes in from the FDA and from the state and all of that.
Before we dive down this rabbit hole, which it really is,
we should talk about contracts and stuff first before we do that.
But what I would want to say is in the transport part, you may need to, depending on where you're located in the States, you may need to speak with local counsel regarding a recommended route by which to transport your hemp. If you're taking it across the state, for example, from Washington or Oregon, you're getting it over here to Minnesota, Wisconsin, you're going to run into an issue potentially, at least there have been, taking it through Idaho. I think we've all seen the articles there where loads of hemp that were seized, and then 7, 8, 9 months later, finally it's getting resolved, but not without criminal charges in the middle, or even issues related to seizure of the crop, and now you've got a time-sensitive crop that's not in a environmentally controlled environment. Right. You got all kinds of potential issues, so it may be worthwhile seeking counsel as to what would be a recommended route of transportation.
I don't think anybody would go in there and sprinkle THC on it just to...
Are you asking me if I have trust in these institutions that we have assigned to govern ourselves?
You plead the fifth, man. You better plead the fifth. Yeah.
Watching recent developments? Okay. Good God. No.
Take a little of that THC out of evidence withholding, kind of sprinkle it on the top, and then sample it.
I have faith.
That's very cynical.
It is cynical.
That's very
cynical. I've worked with law enforcement officers all my legal career, and there are great fellas and gals out there doing a great service. But that does not mean that there aren't institutional failings, and I certainly had a fairly successful career as a criminal defense lawyer, getting things thrown out of court for violation of constitutional rights. So, huzzah. And it helped with purchasing the house. But, there's great people, but the institution has failings for sure.
All right. Yeah. Good deal.
Well, but where were we at? We're going to talk about contracts next.
Oh, yeah, we're going to talk contracts.
All right.
Contracts. Now, contracts, we have social contracts. We have contracts for hemp. We have all kinds of different contracts. Everything in life is run by contracts, right?
Should be. Want it to be.
So you want to make sure that you have, as a processor, the right contract going to either your farmer or to your white label guy or to whoever you're providing the products to. Let's talk about, there's so many different issues here, but let's talk first about receiving the material into the facility. And every contract that I've seen has to have some sort of specifications on the materials, right?
Yeah.
And with absolute clear reject criteria. And why do you do that?
CYA.
Yeah.
Establish expectations between the parties.
Right.
To establish obligations, to establish where the remedy are for violations of those obligations, expectations. But CYA is a lot, right? So we're dealing with industrial hemp. We're dealing with a product that is strictly regulated from growth through processing. And you certainly don't want to be opening up your door because possession is 9/10 of the law.
Right.
Somebody brings in a hot product or a product that they can't prove where it's coming from, or you're accepting a product that you can't prove where it's coming from. Now you've got an audit, you got an inspection, you have a test that your material is being tested, and you are non-compliant. And now who's going to be paying for the destruction of that? Are there going to be potentially other consequences for having a material in there that is non-compliant? Maybe.
Right.
So there's significant consequences that could follow. So you want to have a strictly defined relationship.
Right.
And hey, good fences make good neighbors.
Exactly.
Right. I mean, it's an age-old adage, but it's for a reason. When you know what you're getting and you have that defined, you have it specified, and the person that's bringing it to you has an idea of what you're going to do for them, and that's defined and specified. At least you have a good working relationship to start your relationship off on.
Right. So two people come together, and we have a contract, and I have hemp, and I know that you have the equipment to process, and we're going to come together. I'm going to give you my hemp, and we're going to do either one thing. Either you're going to pay me for that hemp, or we're going to split. We're going to have some sort of split, some barter deal,
type of toll,
some sort of toll or barter or whatever. Right. So, what are the key top things that you feel have to be in that contract from a processor standpoint first?
All right, from a processor standpoint. Yeah. Well, I want to know the material coming in the door. So I need to know how much I have, what the material is estimated to be for its potency, whatever you're measuring that potency by, whether you're buying for CBG, you're buying for CBD, or maybe you're buying for a new cannabinoid that's the season's flavor, that you have a strictly defined range of expected potency, that you have a defined purchase amount for that potency. So, for example, I want to buy 100 pounds of CBD-rich hemp. I'm going to specify in my contract that I'm paying X dollars per percentage point of CBD, and that I am ordering this many pounds. So I have an idea that I'm going to be paying for 100 pounds. I'm going to pay $10 a pound, $15 a pound, whatever it is. At $1 a percentage point, I know that if I have 10% material and I have 100 pounds, I'm going to pay $1,000, right? But that's not necessarily what the CBD potency is going to be of that material. You have to have it tested. Like I said before, right? If you're testing the flower, you're going to have a different measure than if you're testing the whole of the material you're receiving in through your dock. Right. But you at least have these definitions there that you can go back, you can talk with the other party, you can amend your invoice, and it's an ease of transition, and you're not miring yourself in a dispute right off the bat. That's good.
Look, you got to have the contract, because it's the like you said, good fences make good neighbors, and just so that you're agreeing to ahead of time that this is what's going to happen between you and me in the event of something that we don't want to happen. Okay, and like for example, we get in a material that doesn't match the C of A, and it's hot. I mean, a lot of people will make their own calculations on what the return is, for example, from a crop. They'll send it to you, and then you'll do a test and be like, it's 5% or 10 percentage points below what you say it is. That happens. We've noticed because the state, samples the flower and then they chop the whole plant. So that's one thing that we know about. So and that's where complications come in with the contract, because you have a certain level specified on the contract, and then the stuff that you receive in doesn't match it. So you need to have at least a resetting of expectations then based on the material as actually received.
And you should be able to support it as a processor. You have your SOP for receiving, for inspecting, for taking random sampling, for where you're going to have that random sample sent to, that you're going to have any type of dispute resolution between these percentages. Right. And that makes for an ease of amending the contract as well. It's a fairly simple process. You could just be sticking an addendum in there that differently identifies the material in. Right. Another thing that's important, John, is what's the water weight that's coming in? What's the moisture content?
That's a big thing.
It's a big thing because we have a environmentally controlled facility here, but we have specifications that it has to come in usually under 15% water by weight. Right. We'd like it to be lighter, but one of the reasons for that is the likelihood of microbial growth or growing mold on
Yes.
that product and affecting that product is much reduced when it meets those material specifications.
Right.
So I'm not going to get in a really wet product that's going to mold in my house until I get a chance to process it. Now I've got issues related to the processing, and I've got the grower saying, hey, you ruined my product.
Plus there's issues inside of the facility. We're going to go over all the facility stuff related to how you contain and sequester, possible mold within your facility. We're going to be talking about that in detail next week. But it is a real big deal because you don't want your hemp material growing mold. And really, if you're paying for material, you also don't want to be paying for a bunch of water and sticks and stems. You don't want to be paying for rocks or any other foreign matter and debris.
Well said.
Okay.
All of which we've seen. And the other thing is pesticides.
Yeah. Right. Well, yeah. So, I mean, on the pesticide side, that again is specifications, right? So that should be in the contract as well, right?
Correct.
So
yeah, and that it has to be legally compliant material below 0.3%.
Right.
THC, Delta 9 THC.
So can you summarize it in top 3 points?
Maybe. I forget what we
my number one
about.
would be force majeure.
Force majeure, act of God?
Yes.
And how do we define that?
Yeah.
Who is God?
Yeah, all right. This is going to be a long time.
So, right, material specifications, price, and then respect. I mean, then you got your terms and conditions. And I mean, your terms and conditions are going to be a long list of, what the relationship, who owns this product at what point. Is it owned by the processor in transit to the processor? Is it owned by the processor when it's in the warehouse of the processor? Who has
shipping terms?
Shipping terms, insurance liabilities, all those different things. I guess those are, that's pretty much the whole contract. I mean, those top 3, that's the whole contract, I guess.
Okay. I mean, shipping terms are important because, as a processor, you don't want to take liability for, shipping across the United States. I mean, pretty much, they can own it right at your dock. That's what I would say.
Yes.
Seems to be most reasonable. I mean, because they're the ones who are, getting the materials.
Maybe even more important than this is we're dealing with a product that's being processed for eventual consumption.
Yeah.
And so it may very well behoove a processor to consider to what level they are indemnified or indemnifying another who is using that processed material for ingredients in a consumer packaged good or a consumable good. Because these are going into tinctures. They are going into foods, which is a whole other topic, right?
Right.
Is this going into foods, tinctures, dietary supplements? What's the federal regulations?
Yeah.
What are the state regulations? Good God, that's a rabbit hole, baby.
Right. So let's talk about the topic nobody wants to talk about, and that is the in-process materials. So
didn't I say specifically we shouldn't talk?
Yeah,
about
I know, but we have to. We got to talk about it. Okay, so this is where things get a little fuzzy, right? I mean,
they do.
Okay, so here's the deal. So you have a material, and you get it in. It's under 0.3%. It's ready. It's fit for commerce. Okay, and you extract it. And in the event of extraction, you're going to be increasing the amount of THC. And so your oil is going to have, a larger percent than the 0.3%, right?
Correct.
So now I want to send that to my customer back because I've done the extraction. What are the options for the processor to send it back, and what's in terms of risk? Just put it in terms of risk.
I'm not sure if I have a good answer for that.
Okay, because he's a lawyer. I have a potential advice here. Number one, if you send it within the state, it's not a problem. I mean, I don't see any issues with sending it from processor to processor, licensing to licensee within the state as long as it's marked in process. As soon as you go over state lines, I think you're still safe there. You should mark it in-process materials.
If you're going over state lines and you're going from permitted processor to permitted processor, I think you're in a much better low-risk transfer than you would otherwise be.
Yeah, right. Okay. So, but if you're within state lines, it's like no issues.
Not really.
I don't see
there's
that.
not a lot of issues, or just in some discussions with the enforcement agencies within the states, they're aware of this as well, and a lot of them have said, hey, this just isn't clearly defined.
Clearly defined, right.
We know that we've got an initially compliant product. Everybody knows that as you go through the refinement, the levels are obviously going to increase. This bulk oil or otherwise that's created is not a final product. Nobody's consuming that. It's got to be put into a final product, and so they're not seeing a lot of issues for enforcement there.
Right.
But it doesn't mean that somebody who goes in there and parses the law and starts wearing glasses because they've read way too many books wouldn't say, "Oh, I see that there's something here that I could, get elected to office on."
It's a legal issue that needs to be at least understood. Okay,
Yes.
right. So that's why I bring it up, and I think that most people. Get your paperwork in order. Make sure that you're going point to point, business to business, processor to processor, or processor to end to
Manufacturer.
like and manufacturer. Right, exactly. And you should be okay. So that would be my advice. The other thing you can do is you can always dilute it. So dilution's the solution to pollution. So if you dilute it, you can and then have within something that's easily removable. So if it's is that a weight per weight specification?
Well,
in the Farm Bill, like 0.3% weight per weight.
You just ask the questions that open up all kinds of branches.
Why not?
Well,
it's okay.
Because it's a mixture.
Okay.
And what is a mixture?
Yeah, what is a mixture?
A mixture defined by I can't remember the stat. 18 USC 944. I think it is. I don't remember right now. Which is controlled substance, where you're looking at marijuana, is okay. You're measuring out of the whole mixture, right? Does it have this level? Otherwise, in a mixture here, and I have no reason to think that mixture would not be applied in such a situation.
Similar situation.
Similar situation.
Right, exactly.
You'd be fine.
Right.
So especially because we're already dealing with mixtures.
Yeah.
We're dealing with tinctures. We're dealing, full spectrum tinctures are those that have less than 0.3% delta 9 THC within them, right? You got the whole cannabinoid spectrum that's being in this product. So, I guess that's where I'd see it.
Okay.
Hi, Brock. I'm Mel Welch.
Oh, okay.
Yeah, Mel like Welch. Mel Torme.
No,
That'll
Melvin R. Welch,
Melvin,
Esquire.
Yeah, that's correct. That's correct.
Wasn't he the Velvet Fog?
He was.
Yeah, good
Yes.
voice.
Okay.
Melvin Welch, JD, General Counsel at United Science.
Yeah, he is, and General Manager at Nemaji.
Yes.
Yeah. Okay, so we talked about processing contracts now, and we kind of glossed over a lot, but we hit the hard topics. Did we not?
We did.
We did. Okay, now
on contracts though, I want to also talk to processors out there. Listen, you cannot codify business expectations of your customers in that contract. You should avoid that at all costs, because this is a very complex industry and it's a new industry. A lot of the science is being worked out. I mean, at least over here in United Science, we've been working at this for almost a decade at this point, and in developing methods and developing extraction and having good science behind the equipment and the processes. But it is still new. There are a lot of variables that are involved in processing and this product, and through that newness or the novelty of it, and really the lack of established expectations, you'll have business expectations of your customers that are not necessarily reasonable, not necessarily defensible. And as a processor, you're going to find yourself squarely in the position of being the one that needs to answer or fix their errors. And so when you're negotiating
expectations, you're talking about expectations.
Talking
correct?
about business expectations.
Right.
That's correct. You're not in this processing to help them meet their business expectations, except insofar as you can offer them a good product with a good process that is papered, supported by evidence, supported by science.
Yeah, I get what you're saying, and it does make sense. I mean, you have to manage your own business, your own sandbox, right? And there are some things that fall under the category of not your problem as a processor.
Correct.
So just make sure that those business expectations are well established. Great advice, and that was advice from a legal. Legal beagle.
It is not advice. I have offered no legal advice here.
Okay.
Brock Weber.
Bitterness advice.
But I think it's important, especially as you get into these splits agreements. So Mr. Weber here is writing in from North Dakota. North Dakota just passed their industrial hemp program last year, so they're getting into it now, right? So these are problems that we have gone through, that we've seen in other jurisdictions that they're stepping into. And a lot of times where these arise are in splits contracts, right? Basically, instead of the farmer paying you money to process their material, they're paying you in product, the barter system that you referred there to there, John. And so that's where you can get these expectations that can be an issue with those relationships.
So just manage your expectations. And if you don't know what the expectations are, talk about the fact that you don't know what the expectations should be. I mean, you got to be just, look, if you're just getting into the processing, there's a whole business and contract side of doing business, and you just make sure that you have the conversation and do a handshake, and then on the other side of that handshake, do the right thing. I mean, sometimes we've definitely had to take it sometimes where we didn't necessarily want to, and so it is a give and take just to maintain a good relationship. So make sure that is good. Okay, so I think what we're going to do is we're now going to go over the entire process, and we're going to go into the end product itself. So this would be like a consumer product, and let's just talk about the main points of things that people have to worry about in terms of labeling, labeling their product properly, to sell it to a consumer, and talk about a little bit about one of the things that has, like liability or product liability, C of A's, what the documentation is. So let's talk about that. We have studied this now for quite a while.
2 years.
Yeah. And the issue is it's continually evolving, right? So what advice could we offer our viewers here on just labeling?
Sure.
So let's talk about that first.
The Code of Federal Regulations, Title 21, I think it is, Part 21. That goes into all of your different labeling requirements that you're looking at for food, for dietary supplements, for animal food.
Cosmetics,
all that type of stuff. Now, this is the rabbit hole I was talking about too, right? So before I go into that rabbit hole though, so you want to look at the Title 21 that's going to have these requirements. Then you're going to also have to check your own state for requirements as well. I'm thinking of an example here. The state of Minnesota has a requirement that every consumer packaged good, CPG, in its state has to also have the testing facility identified on the label. Not every state requires that, but there are different requirements for different states.
Right.
So it's good to make sure that you know where you're selling into and assure that you're compliant. It also makes for a lot of work, and that's why it's helpful to have an attorney on staff.
Yes. Yes, or at least one on your speed dial.
Yeah, exactly.
So, run it past them, right? I mean, that's what you should be doing.
Correct. Yeah. And the labeling requirements, they're very specific, where you're putting what information in what panel, where the nutritional fact panel goes on here, there, and otherwise. Now, let's go down the rabbit hole, shall we?
Maybe. I don't know. It depends.
Right. Yes.
Which rabbit hole?
Let's go.
Correct. IND and grass.
Do you want to go down that one right now?
I want to go very broadly at it, very broadly.
Okay, broad strokes now.
All right.
Okay.
There is an intrinsic stress in this industry between federal regulatory and state regulatory. This all started up in 2014. Mm-hmm. Feds opened it up to the states. States jumped on board. And at the same time, you had GW Pharma that received IND, Investigational New Drug, application status for cannabidiol. And so where you're seeing nearly all...
For a specific indication.
For a specific indication.
And a specific formulation, yes.
Correct. The feds may not necessarily approach it as narrowly as Dr. Thompson does here, to their shame, but to our pain. And so this is where you're seeing all that conflict, where the feds are saying, listen, you are restricted in what you can have CBD in or marketed as. Mm-hmm. Whereas you have states, and as I've gone through, my last review was like a couple months ago, 33 of the 46 states that have legalized hemp or have programs, they say that CBD is not an adulterant. They say that CBD is allowed in food, and CBD is allowed for these other purposes.
Colorado, for example, I think, right?
Colorado does. I mean, I know Minnesota and Wisconsin have specific. Minnesota has a specific statute on it saying CBD is not an adulterant. Wisconsin has it listed in one of its regulations. But these are in conflict with the state. Now, where does that conflict end, or where is it going? I don't know. Don't have the answer for it. But you need to be label compliant either way.
Yeah.
So if you're going to put out a dietary supplement, you need to ensure that your label, your supplemental fact panel, and your information on there is
compliant with the 21 Part 111.
Correct.
Yeah.
If you're going to have a food out there, you have to have the compliant label.
Yeah.
And that's just the way it is. It's, I don't know, half a dozen one hand, six in the other. I mean, it's kind of that situation.
I mean, you can learn a lot from what is out in the marketplace right now, but I would caution against that because, there are letters being, given out, and people are receiving them because of mislabeling issues, associated with their products. A lot of also, you got to be careful also on your customers and how they review your products and how those reviews are published. Like, for example, if someone took some of your CBD and said, it's cured my cancer, that would be a red flag. Don't publish that. Don't allow that to be published because it's a medical claim that you don't want associated with your product and your label. So,
structure and function. Structure and function.
Right, exactly.
These are the issues that when the FDCA or the FDA is looking at potential violations of the FD&CA, the Federal Food, Drug, and Cosmetic Act. Is this product making structural claims? Is this product making functional claims? In other words, is it making a claim that it affects either the structure or the function of the body in a way that has not been validated by going through the FDA's process? And so they will apply. If, like you're saying, reviews come in and people have been trying to find a solution for an inflammation that's bothered them for 20 years, or an infection here, or pain there. And there is a lot of anecdotal evidence out there, and not just anecdotal. I mean, we actually
It's great.
We actually have actual studies showing, hey, there are efficacious benefits to these to this cannabinoid for this specific ailment for this specific person. But the feds are going to come and they're going to knock at the door, and you're gonna find yourself in a house of pain.
Was that them knocking on the door?
That was them. They're here. We got to go, guys.
Hi, Jets.
Hey, so I think what we need to do is one thing that you could do is a guy could or a gal could go to those letters and learn a lot.
Yeah.
Okay, so they're available online. Go to the letters and see, okay, and that will help you. And consult your lawyer, get your label done, have it go through legal review so that you don't get in trouble down the pike. And don't make all these wild claims because you're just asking for it.
You always got to expect those. I mean, as much advice you're seeking from a lawyer, that they're always going to take a conservative approach, right? Which is if you step out the door, you might get thrown in prison. Right? That's a necessary. Heck, you don't even have to step out your door to get thrown in prison. They're always, But so but you want to have a good assessment. You want to have a good understanding of what requirements there are of you, and then you got to make a business decision based on your appetite for risk. Right.
So that's the skinny on labeling, and it's complicated. We're not going to be able to deal with all of the issues with that, but let me just kind of summarize. First of all, there are issues. You can mislabel. The risk associated with mislabeling is a recall, a forced recall, which was going to cost you a lot of money. So don't do it. Don't take the risk. If you know that your label is non-compliant, switch it, even if you don't think you can market it as well. Because if in fact, anybody could market a CBD tincture or whatever and market it very, very well, but it would be illegal to market very, very well that way because you'd have all these illegal things on it, right? So don't do it. There are a lot of companies out there actually who are kind of ruining it for the rest of us who are trying to be compliant. So just make sure that make sure they're going to get letters,
Yeah,
and they have gotten
every
letters.
every month or every other month, you get a round of a dozen plus letters coming out for the false claim.
It's going to cost you a lot of money.
Claims. Yeah,
it's going to cost you a lot of money.
A lot of money.
Yeah. So so you got 50 to 100 grand into labels and all of your stuff. You're getting it out. You're putting it out into distribution, and then you get a letter.
You've paid for all your sales. You got all the expenses going in with cultivating that relationship, all the time that's going into making a product that's going to be acceptable to this customer.
Right.
And now it's there. It's in the store.
Right.
And now you got a recall.
Yeah.
Now
Just
you've
don't do
screwed
it.
up a customer relationship.
Yeah.
Now you're into your attorney's fees. Now you're calling back all your product.
Don't do it. Don't do it. It's very tempting to basically try to skirt the rule there, and don't do it, because you're gonna get whacked.
Yeah, we're both Eagle Scouts.
Yes,
And so we like to follow the rules.
we do. You're
Don't
prepared.
do it. Be prepared if you're not.
Okay, so also let's talk about C of A's. So with your end product, you have a C of A. Those are typically posted online. Are there any rules associated with that, or are just and how does that really affect the legality of your product?
Well,
Like
you
for
have to-
example,
you have to test the product.
what if I put out a product that had a high THC level in it, too high, and then I put out a CFA that was a little bit less, that was compliant?
Well, that would be false. That'd be false advertising. I don't know that it would necessarily be the false advertising, but
That would be a problem.
You have some level of misrepresentation in your product.
Right.
You've also got a non-compliant product out there. If you got over 0.3, and we get into specifics.
But that
of
just
law here,
happened
but,
recently, right?
I don't recall.
Well,
which one you're
allegedly.
talking about.
Yeah, well, yeah.
Maybe I didn't see it. Why'd you send me an article on that?
Yeah,
Oh, sorry, I didn't.
No
read it.
problem.
Sorry, boss. I read everything that you send me. I must have missed it. Your C of A's. Well, first off, you're dealing with a quality issue. So whenever you have a product that's going out, you need to have a manufacturing record of that product, and you need to have a quality review of that
Batch
product.
record, right?
Batch record, correct. Yeah, I won't go into all the details. Batch record and a C of A that says this product is reviewed. Like I said before, certain states have the requirement that you even list where you're getting tested on the label. We're running out of time here.
It looks like we are.
Now, for legalities, I'm going through my mind here. I don't know why you would never. I don't know why you wouldn't test the product.
Yeah, you'd have. Yeah,
I don't know why you wouldn't. I don't know. I don't know if I can think of a specific law that says you must, but I don't know why you never would.
Yeah, you'd always test the product.
You have to.
Yeah,
How would you be able to put this product out there, make any representations about it?
Right.
Otherwise.
Okay. Well, okay. So then there's no legality, but it's a matter of a brand promise, and it's also a matter of the consumers are expecting to see what's in there.
Yeah.
Yeah. Okay. Well, that's fair enough. All right. So I think we're set. There are product liabilities, things that we could be talking about. Maybe we'll skip 3-4 sessions, and then maybe in the middle of the summer we'll come and revisit.
We'll come back to legal numerous times. We could do a whole session on any one of these topics. I mean, that would be easy to do.
Yeah,
we could do that. So
yes, that's the guy not answering the questions.
Well, hey, we answered a lot of questions, and I so appreciate your questions coming in. We integrated those into a lot of the conversation we had today. So keep them coming in. We will address them in future episodes and as we go. So thank you for that. I so appreciate Mel being here today. Thank you,
Mel. Yeah.
Give me.
Yeah.
Whatever.
Two dorks, John and I. That's how we referred to it. Our drinking sessions. Two dorks.
It has something to do with the Socrates and Narcissus. It's conversations that we typically have.
Narcissistic conversations. We have
no, Narcissus, which is
Narcissus.
Yeah,
yes.
That's the Greek god. Okay.
And I have been witness to a few of those conversations. And it's fun when you're drinking. Okay, thank you for being here.
Appreciate
it. Always in moderation. Spoken like an attorney.
Yeah.
Yeah. Again, our favorite part of being here live is to answer your questions, get you involved. So thank you very much. Subscribe on our YouTube channel. Lots of resources there. calculator libraries coming. Join our conversation on all of our channels, LinkedIn, Facebook, Instagram, Twitter. We're all there. Next episode, again, is everything facilities. So I'm sure we'll touch on legal issues there as well. But that's going to be good.
That's going to be good. Okay.
I think it's going to be
really Let me give an intro just off the top of my head. I don't even know what we're going to talk about, but this is what's in my mind. Okay. Making sure that your hemp processing facility is apportioned properly. So that you're able to make sure that you're not getting cross-contamination. That's number one. Number two, we're going to be talking about occupancy and requirements for occupancy. We're going to talk about building types, how that really relates to the maximum amounts of solvent you can have in process and use, and also in storage, where you would go about storing your solvents that you would have. How to establish different control areas. We'll talk about C1D2 classification, C1D1 classifications, solvents. It's going to be awesome.
That is going to be awesome.
Oh,
and can we add into that kind of a little bit of timing? So since we're talking about where things are stored and where we're quarantining and where we're putting biomass and where we're having freezage happening, winterization and things, can we talk about the timing as well? And just
we can do that too. For sure.
Because that would be a whole episode. But there's a lot of questions that have come in about timing issues, and I think that would be
okay.
Really
that's good. We'll illuminate.
That
It'd
would
be good.
Awesome. Good. So we will see you next week, noon Central, next Thursday. Thank you. Thank you for being here. Have a fantabulous weekend. And Mel, good to have you here.
My pleasure.
Dr. Jon, always fun. Thanks.
Thank you. See ya.
All right.
Bye now.
Are you stuck in your hemp or cannabis business? Are you not reaching your processing goals? Here at extraktLAB, we offer a free 20-minute CBD Jam Session. A CBD Jam Session is a conversation with an industry expert, not a sales call. A conversation where you can talk to us about whatever issues you are having right now and where you are stuck. We will help you uncover any issues you are currently having in your business, create a solution to fit your current scale, develop a future scale-up plan based on your needs, and help you make your processing goals a reality, all while getting your business plan back on track. Schedule your free 20-minute CBD Jam Session at 1-651-600-0036. Again, that number is 1-651-600-0036.